Okay, welcome back, guys. So we'll begin with Article 31, which has been removed, deleted, repealed, whatever you say. Legal word is repealed by the Parliament using the 44th Constitutional Amendment Act. Why? Because there was a tussle between the Parliament and Judiciary for a long time. Finally, in 1978, it was repealed. Okay, the word should be repealed, not deleted. In constitutional language, we say repealed. So now Parliament has provided three shield clause for themselves. How? They wanted to bypass judicial actions, so they introduced this. But later, during studying these, we will understand how judicial developments led to the power of judicial review, covering these also. Okay. So the first one is 31A. This subclause specifically protects Zamindari abolition and agrarian reforms. What this means is, like Ceilings Act, Land Ceiling Act, etc., which aims at giving or taking away land, shall be protected using this. Okay. The 31B, this gives protection to laws put in the ninth schedule. But the most controversial part is this ninth schedule. Parliament created a ninth schedule saying that whatever we put in this ninth schedule shall be immune to the judicial review. What this basically means is Parliament is trying to impose parliamentary sovereignty, as in case of UK. But here in India, we know that no organ of the government or the state is sovereign or supreme. There is a system of checks and balances. So Supreme Court in 2007 said that whatever you put in this ninth schedule shall be open to scrutiny using power of judicial review by the courts. And which courts? Both Supreme Court and the High Courts. And we will discuss also this code of record. Okay, while covering judiciary, we'll specifically understand this and how the Supreme Court is the final arbitrator, yet the Supreme Court is not above the High Courts. It is a very like saying that in hierarchy terms, Supreme Court might feel like they are above the High Courts, but in recent judgments, Supreme Court can only give guidelines. They cannot put absolute terms to the High Courts. It has been said by the Supreme Court itself. So we will understand why this system is as such. Okay. Why these are done? For this social welfare and DPSPs. I have told you already. So now we will see Article 31C. As in case of 31A, 31B, so is the case of 31C. It is for protection of certain laws which will be made by the Parliament. So protects the laws implementing 39B and 39C. What are they? DPSPs. They are taken from the Irish Constitution. What are they? Directive principle of state policy. Okay, we will discuss after fundamental rights. We are coming to that only. So 39B and 39C are for distribution of resources. So for implementing these DPSPs, whatever law the Parliament may bring, the Supreme Court cannot challenge. Okay, but what happens is, you will understand in judicial review and the judiciary section that we will cover, that still the Parliament can see if it has been passed in good faith or not. Nothing in India can be arbitrary. Always remember, in India, parliamentary supremacy is not there. You can say that somewhat judiciary seems to be supreme over parliament, but not in every aspect. Judiciary's power of judicial review holds true in certain cases. Parliament's power, like bypassing Supreme Court's order by a retrospective, or what is retrospective? If you remember, like Supreme Court of India passes a order in 2026. So, what the Parliament will do? they will change the law itself and say that this is applicable from 2025. So this goes null and void. In certain cases, Supreme Court of India also cannot do anything. So here is a system of checks and balances. Okay. Article 32, the heart and soul of Constitution of India. Okay. Why? Because everything goes vain, everything goes down the river if this is not present. You have been given all the rights, everything on paper, but you cannot approach any authority if your rights are violated. How will you make sure that you are actually enjoying your rights? So who will actually help you in case of violation by the state? It is the judiciary, higher judiciary. Okay, Supreme Court of India and high courts. These are courts of record. Article 32 enables the Supreme Court to issue 5 writs. Everybody knows it. But understand this, there's a nuance here. For fundamental rights, only Supreme Court can be approached. For other things, including the fundamental rights. So if you are approaching the Supreme Court to issue certain rights, the writ petition or writ jurisdiction, actually, the writ jurisdiction of Supreme Court is narrower than the High Court. It sounds strange, but it is true that Supreme Court can only issue writs in case of violation of fundamental rights. Okay, but High Court can issue writs in almost all the cases. What are those writs? And High Court does that using this Article 226, Supreme Court using this Article 32. Okay. Right to constitutional remedies. The first one is habeas corpus. You can remember this as to have the body or produce the body. Very important part of the constitution, these 5 rights. Questions has been asked in multiple examinations, including the examinations conducted by the Union Public Service Commission, okay, which we are aiming for, like the examinations of UPSC, NDA, CDA, CAPF, and including CSE. So to have the body or to produce the body, this particular writ is issued by court of record, that is High Court or Supreme Court, against whom? Both the state as well as individual action. Okay, this is more important than just remembering this, because question can be formed against whom this writ is available. That is more important. Okay, remember that as well. If you just remember this definition, it is of no use. Mandamus, that is we command. We are commanding to whom? The judiciary can command to the executive. Okay, so they are giving a command to the executive, that is public officials. And remember guys, this does not include the governors and presidents. Okay, yes, they are the head of their respective executive authority, but this is only applicable to civil servants, etc., etc. Prohibition, prohibits or forbids. And to remember this, prevent. Related with this, I'll tell you why. This is issued to a judicial as well as a quasi judicial body. Quasi means which seems like a judicial body, like tribunal. Okay. Prohibition aims at preventing something. Like the Supreme Court or the High Court thinks that there is a certain case going on in particular court, so or a quasi judicial body, what they can do is, even before something happens, they can direct that court or quasi judicial body to do not take any action or stop from doing certain things. Remember the word prevention for that prohibition, and for this certiorari you have to remember cure. We know a line that prevention is always better than cure. Prevention comes first, cure comes later. So it is always better to prevent certain disease or like accident rather than just curing it. So prevention comes first, prohibition comes before a judicial action has been taken. This Certiorari comes after an order has already been passed. So remember the words which I have told you: quash an order already passed. Order has been already passed by judicial or quasi judicial body. Quasi judicial bodies are tribunals, etc. Like CAT, Central Administrative Tribunals, which are made for the civil servants. Okay, by lower court, judicial body. Quo Warranto. On whose orders or on what authority? By what authority? If a person has illegally or might be legally taken over a public office, so who will, anybody can go and approach the court will issue this writ, and that person will have to justify their like taking up of that office. Okay, now we will see the article 33 and 34, and this is for restriction of fundamental rights for the armed forces, police and intelligence agencies. All these agencies are for law and order, internal or external, so they need to maintain certain discipline. And many of you might be preparing for NDA CDS, so you understand the aspects that the rights, the powers, freedom, liberty that a citizen enjoys is not exactly available to a soldier also. Why? Because they have to live their life in discipline. Discipline is formed through like hardships. So every freedom cannot be enjoyed by a soldier, and that makes sense also. So they cannot like form associations, etc. So this whole part, that fundamental rights part, is applicable with certain modifications. Restrict FRs. Restrict means withhold fundamental rights of these agencies. There is a judicial development here. First one is it applies to non-combatants also. This does not only mean the ones who are wearing uniforms or the ones who are actually on duty on the field, but the ones who are present in their campus and are doing any kind of work, including the administration work also. So their fundamental rights can also be curtailed or restricted by parliamentary law. Why? Because they are in the same uh, campus or whatever you say, so they also need to be following the same discipline. Okay. Second judicial development is here. Law made under Article 33 can also bypass Article 32, that is fundamental rights or fundamental rights as a whole. I'll explain what this means is. If a commanding officer gives certain punishment to his company, so what can they approach the Supreme Court? Our rights have been violated, we have been given this punishment. I am giving this a small example. Fundamental rights can be curtailed in different ways, because in situations for serving the country, these people are absolutely heroes. These are the actual heroes who are serving the nation. What you see in cinema and etc., they are not heroes. I would like to say this, that always remember, in any country, these people are really really important. So for them you should have respect. So their rights are determined by their superior officers. Okay, now we will see the Article 34, martial law. What is martial law? When in any part of the country a situation arises that the army has to take over, so the government can impose martial law, and during martial law, normal administration has been dissolved and taken over by the armed forces. Okay, it can also be in case of border areas, so as to maintain the peace, and also so that the citizens of India are saved from certain nuisance. Okay, so when martial law is in application, certain things are there. Okay, the rights of common citizens also underwent a change. We have to understand this indemnity clause. When martial law is in place, an officer of the armed forces or empowered by the armed forces, if they do certain acts which are in normal times not acceptable, but they have to do to maintain security and integrity of India. So they have to, might be like in certain cases during combat with the uh, any particular like insurgent, what happens is the civilians gets killed, so they can be made indemn to this. Okay, what this means is they can be pardoned for that. But here also judiciary said that judicial review is available. It is not a license to kill. Okay, you will understand this, that judiciary in India is absolutely very powerful. They can look into any matter if it, and specifically those matters in which the fundamental rights of any citizen are violated, the judiciary is empowered to take any action. Okay, the finalizing clause, Article 35. This is the monopoly of the Parliament of India, the supreme legislative body in India. Okay, the Parliament can and the state legislatures shall not. This is the line written in that constitutional text, if you remember. Okay, remember, state legislative assemblies or the legislative assemblies of the union territories are absolutely not allowed to do any changes in this part. Why? Or even in their respective statutes, that certain fundamental rights will be applied this way. No. One India, one system. Final. Okay. Why this is so? If you understand Indian polity, if you know why there is one citizenship, I think I have discussed during that preamble. So if you want to know, you can check the preamble video. Okay, this is the part one. This is the 35B. Okay, okay, a very powerful clause. This B part says that all the pre-constitutional laws that are in force at the commencement of this constitution, even they, if they are passed by a respective legislative assembly, then also the parliament is empowered to change that or repeal that. No role of any legislative assembly. Okay, so this brings us to the end of this fundamental rights. Now we'll look into the DPSP starting from 36. That is just the definition of state. Until and unless stated otherwise, that definition of state holds true here also. That is the meaning here in 36 article. So I'll just discuss DPSPs. Why DPSPs are not directly incorporated as fundamental rights in the constitution? Most of you know the answer if you have been preparing for these exams. To understand that answer given by almost everybody, that during the formation of our nation for independence, we were actually not in a state to implement everything at once, and the resources and financial burden that would bring to the national exchequer would be very high to implement everything at once. We cannot be giving like distributing everything at once. So these DPSPs are certain things which the parliament, if they want, they can convert into fundamental rights, like right to education is a classic example. Okay, DPSPs or fundamental rights, there is always a battle. We'll discuss this also. So if you know the answer, which one is supreme over the other? Which one is higher? Fundamental rights or DPSPs? Is there any clear winner? We will study all the judicial developments that have taken place regarding these, and what this judiciary has finally, I'll just tell you the final answer, but we will look also all the matters, whether what were the cases which led to these, that none of them are more important. These are two wheels, both are needed for running of a cycle. So nobody is higher than the other, both have to support each other, and in certain cases FRs are made over higher over DPSPs, and in certain cases like in 31C, I think this one is given a higher priority. the name of social welfare. Okay, so now we will start DPSPs in the next class. What I want you to do is go do the fundamental rights questions from previous year questions. If you have any problem, just write down in the comment section. Okay. Also give a review whether you are liking the class or not, and you can write anything. Okay. Thank you so much.